Hello, everyone, and welcome back. Brand new episode 5 of Inspector Claim Talk with the preeminent home inspection litigator in the country, Mr. Joe Denneler. Joe, since it's episode 5, we're going to do 5 commonly asked questions for home inspectors. What do you say?
I think this is going to be a great topic, and I guarantee that people will learn something from this.
Awesome. Let's jump right into it. What are the most common accidents that happen to inspectors?
That's definitely the first one, the most common question I get when people ask, why they have to have general liability insurance in addition to their errors and omissions, because general liability covers you for accidents. And I'm often asked, well, what do you mean? What's an accident? Well, the most common ones we see with home inspectors are overfilling a sink or a tub, stepping through the ceiling from above from an attic, and then broken automatic garage doors. If I look back at the last 3 years that we've been operating the insurance program with InterNACHI, that we've seen, those 3 have been the most prevalent accident claims. And so the overfilling ones generally involve the inspector, running the tub or the sink, going into another room and performing some other aspect of the inspection, and then coming back to find that the water ran a lot faster than they thought, or perhaps the sink was clogged and they didn't know it when they turned everything on, and then we get a water event. Some are worse than others. We have them where we have standing water coming through ceilings and into various rooms of the house, all the way to just minimal ones that affect the immediate area in that bathroom or kitchen where the water source is. But we get quite a few of those, and we have to jump on those right away as an insurance company. I had one yesterday. My insured called us at 3:30 in the afternoon and said, "Hey, I'm at this house right now. There's water everywhere. I flooded the place. What do I do? The homeowner's losing their mind. The place is listed for sale. They can't show it." We jump right on that and arrange for a crew to come out there and immediately start drying the house and cleaning everything up, because it's hugely important. It's also important for our insureds, because the inspector needs to show the agents involved in the transaction and the parties that, hey, even if I made a mistake, I've got somebody behind me who's going to jump right on that and take care of it for you. And so we have to respond to those right away. The ones where they step through the ceiling from the attic, unfortunately, it's usually the inspector that's harmed more than anybody else. Drywall and ceilings, it's relatively easy to fix. But so I always recommend to our insureds, when you go into an attic, make sure you're very clear about whether you have any place solid to stand or not before you traverse that attic. Unfortunately, sometimes we get caught up in the moment of what we're doing in our jobs, and we forget to take care about the most important thing in that situation, which is our own personal safety. So we do see that happen from time to time. Again, we jump right on getting a carpenter or somebody else out there to make the repairs for the cellar, so that they're not disparaging our insured or that upset. And so the agents involved know that the inspector's taking care of something. And then, the broken garage door openers, I've had many occasions where the insured just goes in there and tries to operate the door in the way any normal person would, and it fails during that test, and it causes damage. Unfortunately, most people would say, well, the inspector was doing the inspection at that time, therefore they're responsible. And so we deal with claims regarding that all the time, and the inspector's not always responsible for that, as you can imagine. But those are the 3 top accidents we usually see with home inspections.
What system of a home is usually involved in the claims involving high damages?
That's also a big ticket question, because when people talk to us about the insurance, they always want to know, well, why do I need the insurance? Most claims are going to be nickel and dime stuff. Well, that's not true. The system that's most involved in the high dollar claims is the structure. And there's several reasons for that. First and foremost is it is the most expensive thing to fix. It usually involves having to bring in an engineer, possibly an architect, and some kind of structural contractor to diagnose what the defect is and what the appropriate repair is. Because the nature of those repairs are so expensive and time consuming, they're usually the ones that a claimant will pursue further than just making a complaint. There's a lot of occasions where they're going to file a lawsuit on that immediately, because most homeowners don't have $75,000 or $100,000 laying around after they buy a new house to go in and jack up the house and put more supports in where there's a foundation failure or a structural failure involving a foundation. The average cost that I've seen over 2022 for our structure claims for repairs. And this is where they have to actually make repairs to the foundation by jacking it up or installing piers. Generally in the neighborhood of $50,000 to $75,000, although I have some that are in the $125,000 range. So as you can imagine, that's something that a lawyer would latch onto and say, hey, I'll take a case for you, homeowner, because there's enough money in that kitty to probably pay my fee. So it's more appealing to a plaintiff's lawyer to take it on a contingent fee basis, which makes it a little easier for the claimant to get a lawyer to represent them in court on that type of claim. So it is the reason it's high dollar is the cost of the repairs, but that's also the reason why you need errors and omissions insurance, because just like most homeowners don't have that cash laying around in a sack somewhere, most home inspectors don't either. And a claim like this can happen. You can make an honest mistake, or somebody can accuse you of making a mistake you didn't make. But either way, as you can imagine, something like that would break the bank on most smaller home inspection firms.
Yeah, that's a perfect segue into my next question, which is, when does a complaint actually become a claim?
We get this all the time, especially with the insurance company. And so, in our policy, I can speak directly about our insurance policy with EliteMGA and InterNACHI, is that a claim is when somebody makes a written demand for money from you for damages and allege that you did something you weren't supposed to do, or did something negligently, or breached your inspection agreement with the client. And so that's when it really triggers it under the policy. Now, our company has what we call worry-free reporting, which is, we're actually really proud of this because it's important, and it's important for our insureds. When I was practicing law for 20 years before I came to Elite, and I was defending home inspectors in litigation, the worst calls I would get would be the call where the inspector says, hey, I turned this into my insurance company. They denied coverage. And as a result, can I retain you and pay you out of pocket to help me with this case? And it was usually a situation where the insured, had some notice that there was going to be a claim related to this inspection, or that they had, notice, they had a lawyer letter that they kind of blew off and left on the desk, or, they got something from a court and they didn't tell their insurance carrier about it. And the carrier denies coverage and says, well, you knew about this before you got the policy, or you knew about this when you applied for your renewal and you never told us. And as a result, we're gonna go ahead and deny the claim. Worry-free reporting means that you can report anything to us, and it doesn't count as a claim just because you reported it to us. A lot of our competitors, anything you turn into them is a claim on your policy, and you carry that with you when you go to get a renewal or go to another company. You have to take that loss run with you, and that follows you. And so that an insurer looks at that loss run and says, well, you had a claim here. We don't want to penalize people for reporting things to us that we can help them with. And so we want you to report everything to guarantee that we always have adequate notice, and so that we never have to deny a claim and say, well, you didn't tell us about it when you first found out, because most of errors and omissions policies are claims made and first reported policies, which means you have to report it during the policy period when you first became aware of it. And unfortunately, a lot of inspectors end up reporting it after that policy is already renewed to the next one. And so they have a problem. You can report it to us. If it's something we can help you get rid of without having to write a check above your deductible amount on your policy, we don't count it as a claim. And so we'll help you resolve it. We'll prepare a release for you that adds confidentiality so that they can't repeat it, and is a clear, release of any and all claims, whether known and unknown. But let us help you with that, because we don't want you to have a bunch of claims on your policy. We want you to have smooth sailing with regard to your insurance. And so that's why we let our insureds report everything to us without worrying about it being a claim, unless we have to spend money above the deductible. And usually that's going to happen if they get served with a lawsuit. Those expenses add up really quickly. And more often than not, anything that comes from the court, anything that's a lawsuit or a demand for arbitration, is going to end up being a claim.
Is an inspection agreement still enforceable if it gets signed after the home inspection?
Man, this happens all the time. Most insurance policies that require that you have a signed inspection agreement in order for coverage to attach require that it be signed before you do the inspection. If you're in a state that has regulations, New Jersey, Massachusetts, New York, if you're in a state that has its own regulations related to the inspection contract and the timing, it likely says something to the effect that the agreement has to be entered into before the inspection. So in terms of whether or not that's important for coverage, it can be critically important. Now, a lot of inspectors have systems set up that are automatic where the client can't, for example, read the inspection report until they electronically sign that inspection agreement. And that's good, but unfortunately, it might not work in certain states because they require specifically that it be signed before the inspection starts. So it's not always going to be enforceable if you do it that way. And the best practice is to get it out to the client within, one business day of them making the appointment with you, and then making sure it's signed before you do any part of the inspection whatsoever. It's unfortunate. A lot of our insureds, they're the only person who is on time for anything related to this real estate transaction. If you've ever been a buyer or seller, you know what that's like, that it's difficult to get everybody there on time. And so a lot of times our insured is the one there ready to go and get their job done in a timely fashion. And so maybe they'll start the exterior, or maybe they'll go up on the roof while they're waiting for everybody. And then when everybody gets there, they go and have their client sign the agreement. Well, that's not good enough. And if you're in a state that requires that it gets signed beforehand, it might not even be enforceable. I had judges throw out an entire agreement before because the insured didn't get it signed and send it out in accordance with that state's laws on how that inspection agreement has to be delivered, when it has to be signed. So I'm going to tell you that that fail-safe isn't always going to save you. And the best practice is to have it signed before you do any part of that physical inspection. Otherwise, you run the risk that it might not be enforced by a judge later on. And if you're in a state that enforces things like limitation on liability or allows you to limit your inspection to certain systems and components, if that agreement's not there, you don't have that written agreement with your client. So it's critical, I think, that you get it signed before you do any part of the work.
And then the final question that I have for you, Joe, is let's say a home inspector had just been sued. Can they countersue further legal fees?
I'm smiling, not because it's funny, but because when people get sued, but because this might be, I made it number 5 here. We did 5 questions for our 5th episode, but this is the one I get every time somebody gets sued almost is, this claim is frivolous. This lawsuit is frivolous. Can I go after them? I want to countersue them for my fees and costs and for defamation and anything you can think of. And, unfortunately, the short answer is no. Because in the United States, we follow the American rule when we talk about legal fees. So what that means is when you go to court in a civil action and claims against a home inspector are going to be civil actions, each side pays their own freight. Each side pays their own attorneys and all their legal costs related to that lawsuit. Now, the exceptions to that are generally if there's a written agreement among the parties as to the allocation of attorney's fees, or if the cause of action, are you claiming they were negligent? Are you claiming they breached a contract? If in that state, the claim that you're making allows you to recover attorney's fees by statute, that would be an exception. But mostly, no, you can't get them. You would have to rely on your state's frivolous litigation statute or bad faith litigation statute. It's called different things in different states. That's a very high bar. In those, you generally have to prove that the plaintiff's lawyer and the plaintiff definitely knew that their claim against you was frivolous, that it had no basis in fact or law by any reasonable interpretation, including no reasonable extension of laws that exist. You have to prove all that in order to prove frivolous litigation. And then you have to go try to recover those fees from a party that has no insurance for that. So it's nearly impossible. In my 20 years representing home inspectors before I came to Elite and Internachi, I had one time a judge allowed those damages for me in a case because it was just ridiculously frivolous, and they had every opportunity to withdraw it before I got it kicked out of court. But that's one over 20 years. And as you can imagine, that's a pretty small, number in terms of that sample size. So generally speaking, you can't. Now, some inspectors put a provision in their inspection agreement that says, hey, if you sue me and you lose, you have to pay all my fees. Or they do one that at least sounds more fair, which is, hey, if we sue each other, the party that loses has to pay the other side's fees. Now, some courts might enforce that. Generally speaking, they're not going to enforce that against a consumer. So if new home buyers, with very little resources, in good faith file a lawsuit, a judge may not enforce that fee shifting provision against them. And so you can't rely on that to try to get your fees back. Unfortunately, when you're sued in this country, unless you have a slam dunk case that they did this knowing full well that there was zero basis in law or fact, you're not going to get your fees back on a countersuit. But I will tell you this, as an insurance company, we recognize our insureds are concerned about that. And so we look at that in every case, and we will gauge that. And so we'll always consider it. Not every insurance company will, but we do, because inspectors are our bread and butter, and and we try to take care of this industry as best we can. So we'll always look at that for you, but I'm going to be brutally honest with you and say that it's a very, very narrow window for that air to come in that includes you getting your fees back.
That's it for episode 5 of Inspector Claim Talk. Great stuff as always, Joe.
Thank you very much, everybody.